The International Covenant on Civil and Political Rights (ICCPR) is a multilateral treaty adopted by the United Nations General Assembly on 16 December 1966. Article 49 allowed that the Covenant will enter into force 3 months after the date of the deposit of the 35th Instrument of Ratification or Accession. The Covenant commits its parties to respect the civil and political rights of individuals, including the right to life, freedom of religion, freedom of speech, freedom of assembly, electoral rights, and rights to due process and a fair trial. The ICCPR is part of the International Bill of Human Rights, along with the International Covenant on Economic, Social, and Cultural Rights (ICESCR) and the Universal Declaration of Human Rights (UDHR). The ICCPR is monitored by the United Nations Human Rights Committee, which reviews regular reports of states parties on how the rights are being implemented. States must report initially 1 year after acceding to the Covenant and whenever the committee requests, usually every 4 years. The committee normally meets in Geneva and normally holds 3 sessions per year. The Covenant can be divided into a preamble and 6 parts. Part 1 to 3, Articles 1 to 28 constitute civil and political rights comparable to European and American Conventions on Human Rights and African Charter on Human and People's Rights, and majority of these are negative rights, and briefly they are the right to self-determination, the right to life, freedom from torture, degrading treatment, and freedoms from slavery and slave trade, right to liberty and security, the right of detained persons, freedom from imprisonment from debt, freedom of movement and choice of residence, freedom of aliens from arbitrary expulsion, right to fair trial, prohibition against retroactivity of criminal law, right to recognition everywhere as a person before the law, right to privacy, right of freedom of thought, conscience, and religion, right of opinion, expression, prohibition of propaganda for war and of incitement into national, racial, or religious hatred, right to peaceful assembly, freedom of association, right to marry and found family, rights of child, political rights, equality before the law, right of persons belonging to the minorities. There are 2 optional protocols to the Covenant. The first optional protocol establishes an individual complaints mechanism, allowing individuals to complain to the Human Rights Committee about violations of the Covenant under Article 14 of the Convention on the Elimination of All Forms of Racial Discrimination. This has led to the creation of a complex jurisprudence on the interpretation and implementation of the Covenant. As of July 2013, the first optional protocol has 116 parties. Parties agree to recognize the competence of the UN Human Rights Committee to consider complaints from individuals who claim their rights under the Covenant have been violated. Complaints must have exhausted all domestic remedies, and anonymous complaints are not permitted. The committee must bring complaints to the attention of the relevant party, which must respond within 6 months. Following consideration, the committee must put forward its conclusions to the party and the complainant. The second optional protocol abolishes the death penalty. However, countries were permitted to make a reservation allowing for use of death penalty for the most serious crimes of a military nature committed during wartime. As of December 2017, the second optional protocol had 85 parties. This optional protocol commits its members to the abolition of death penalty within their borders. Through Article 2, subsection 1 allows parties to make a reservation allowing execution in time of war pursuant to a conviction for the most serious crime of a military nature committed during wartime. Cyprus, Malta, and Spain initially made such reservations and subsequently withdrew them. Azerbaijan and Greece still retain this reservation on their implementation of the protocol, despite both having banned death penalty in all circumstances.